Lee, thank you so much for joining us today. As we start, can you say a few words about your current role?
Hi, yeah, definitely. Basically, what I do day to day in terms of my full-time job is that I'm senior principal of cybersecurity and privacy for an entity called HIMSS. It's a global healthcare nonprofit dedicated to ensuring that everyone everywhere has healthcare through healthcare information technology. My position is senior principal of cybersecurity and privacy, essentially functioning as an industry SME in terms of
Mhm.
both realms.
Awesome. I know you recently had a major conference. Uh, I imagine you probably were involved in programming or participated in it. What were your major takeaways and learnings from that event?
I think the major takeaways included, in terms of the uptake of artificial intelligence in healthcare, that's definitely proceeding with full force. Is there hype? Obviously, there's still hype around AI.
Mhm.
But I think that there's meaningful uptake too in terms of AI, although certainly various organizations have concerns one way or another regarding how do we essentially adjust to the new risk environment, essentially, in light of AI, in light of AI-fueled attacks. So that was certainly the subject of much discussion, and being that we're healthcare, we're always under scrutiny, it seems, for breaches and other things that are happening. So certainly some of the major incidents that have happened were very much talked about, including the what are the cascading effects of a breach, as we recently saw in the from the payer perspective.
Certainly. Well, if we talk about healthcare broadly, well, first is personal identifiable information, which is sensitive in itself, right, for identity theft and things like this. But also health-related information is highly sensitive for people who um, obviously would prefer not to disclose certain aspects of their health history, and obviously I cannot imagine anyone who would not prefer to keep details of their health history private for various reasons. So hence probably the scrutiny, and hence the interest from bad actors in these attacks, because it seems like in certain respects, unfortunately, crime still pays, whether it's for ransomware purposes or for identity theft purposes. We see recently, specifically about personally identifiable information and privacy, California has its own act. There's kind of can spam, and there are various state level regulations. Recently, I saw a new bill. I think it's called American Privacy. Is the idea is to create a unified document at the federal level, and it's somewhat recent. You mentioned that you saw some of the details. Can you comment as to what this would mean for the industry, being healthcare, but also broadly for cybersecurity practitioners?
Yeah, absolutely. So reading through the bill, there are two main strands, I would say, that I took away from the bill. One is in terms of the creation of individual rights, similar to the California CCPA,
Mhm.
CPRA as amended. We certainly see that where ourselves as individuals, in terms of information that may be personally linked to us. There's the right of access, the right to collect, amend, delete information, or even the right of portability of our information. And so whether you're a covered entity, or if you're an entity that supports a covered entity, in the lingo of the proposed law, that means a service provider, you're essentially on the hook. You're on the hook as to ensuring that there is a degree of fundamental rights that individuals now will finally have, assuming that this privacy law is enacted. And there are also things like FTC is, I suppose you could say, it is broadening its powers with the scope of this law. FTC, as we know, will be the enforcer for this. And a very key thing to note with this new proposed legislation are, I think, a few things. One is individuals now have the right to be meaningfully informed about the information with which their, for which their information is being processed. And for the most part, individuals will have the right to express their affirmative consent to have their personal data processed by a covered entity. And I think that's really important because before that, I'd say, as we all know, in the United States, our privacy laws have been fairly weak. Consumer information, especially, is widely and wildly spread about, amongst businesses, amongst others. And while the various states have had their own versions of what you can and can't do with consumer information, it's been a hodgepodge. So what this proposed privacy law does is that it attempts to harmonize, and actually, essentially, if you were to look at things like Section 20 with preemption, it attempts at least to preempt what state laws are trying to do, albeit inconsistently, in terms of championing privacy rights and controls as to that data and the extent to which people should know about how their data is processed. So that's really remarkable. I think that certainly in Europe and many other countries, the fact that there's a tighter rein on data and the control of that, and even layering on top of that, as we know with this privacy legislation, it's not just simply privacy legislation, but there are additional security controls that we must implement depending upon the level of risk associated with that information. And that certainly for us security practitioners is important. And if we're like, well, so what, this is something that eventually may or may not happen, well, the one thing that gets all of our attention, frankly, with just about any industry is if there are significant fines and penalties and or even bad press for organizations, that'll certainly make us listen, right?
For sure, for sure. And kind of with this in mind, it seems, well, one, this bill, if passed, will bring about unification of compliance requirements, but also it would necessarily mean increased compliance requirements on players in the healthcare industry. And with this in mind, I wonder, what's your opinion on and certain providers collecting information that they're not they don't need to perform to deliver healthcare. I want to share kind of a personal anecdote. I was recently I received a text from a doctor before an appointment. They wanted me to fill out a form in which they not only ask the history and allergies and all kind of the relevant pertinent questions, but also things like marital status, social security number. They wanted me to upload my photo, and a couple of things that came to mind. One, those fields were not required, so I didn't include any of that information and completed the form. So it was not required from the healthcare provider to collect them, yet they're asking for it. And the second comment for me, I was just in the back of my mind, I was, well, if I provide all this information, can I see all the security protocols, how this information is stored, handled, and processed, and what kind of audits you perform? And it's really a small office, so I doubt they have a dedicated cybersecurity professional. At best, it's an MSSP somewhere. So do you think this increased compliance will push healthcare providers to reassess what kind of information they're collecting and which information is essential to delivery of healthcare and which information they're better off not collecting, so that not to put themselves under further more stringent compliance requirements than absolutely necessary? What are your thoughts on that?
Well, in terms of the applicability of this proposed privacy law, it specifically makes clear, though, that if you have existing federal obligations such as HIPAA, well, it doesn't specifically name that, it says that by no means do we abrogate anything or override anything that HIPAA or other federal legislation or regulation may say. So there's that. There won't be any conflicts or contradictions or overriding of anything there. Now, the HIPAA privacy rule itself, as it stands now, does have a the minimum necessary standard, as we know. And that essentially means that notwithstanding for treatment purposes, typically minimum necessary means the absolute minimum necessary. Of course, you need to do a certain function, something that's reasonable, and that's a true, tried and true requirement. Notwithstanding that, though, outside the scope of things like HIPAA and hospitals and vendors and accountants and lawyers and everyone else who support hospitals and doctors' offices and healthcare insurance companies, right? We in the healthcare industry for many, many years have recognized that there's a significant hole, if you will, in terms of who's regulating entities that push out things like health and wellness apps that might collect things like sleep information, other physiological information that's not been handed down, prescribed, so to speak, by hospitals. And certainly there's at least some colorable argument that FTC Act Section 5 has some kind of applicability there. But to what extent do we really have teeth, I think is what you're asking. And I would say, in light of at least this introduced, proposed privacy legislation, the very fact that it requires things like, and let's just say the good things in terms of those of us that are privacy champions out there, things like data minimization. Are you using the absolute minimum necessary that you truly need? And of course, the consent factor. Absent something like a legal obligation to process the data, such as pursuant to a contract, do you actually have meaningful consent from that person? I mean, you had said rightly that there were certain fields, for example, you didn't have to fill out, and that's well and good. And maybe for payment purposes or whatnot, maybe an entity may need additional identifiers as they're considered under the privacy rule. But if you can opt out, I'd say that's a wonderful example of minimum necessary under HIPAA.
Certainly. Well, it's interesting. It's a very good perspective, and I think I would imagine that from the healthcare provider perspective, I would think they absolutely will reassess what information is absolutely necessary and what information is redundant, because it's with increased compliance, they'd much rather not collect it, not store it, not report on it, and only focus on what's absolutely necessary for performing effectively delivering healthcare. But I think it still remains to be seen if the bill does pass. It will end up being passed, how this will impact the healthcare. But I just want to double click on another thread. You mentioned SAC, and recently, as you, I'm sure, saw in the news, SAC brought action personally against CISOs of certain companies around breaches that recently happened, without going into specifics. And this most clearly increased awareness on the part of CISOs and other senior executives in regards to potential personal liability and what it means and what potential steps they need to take to protect themselves personally, not just under the corporate umbrella, but specifically them as individuals. And obviously this is all new and fairly new and evolving. From your perspective, what will be your advice for CISO, whether healthcare or not? What are 2-3 things he or she should focus on to protect them on a personal level, you think?
Absolutely. So in terms of a few basic things, the first thing that comes to mind, of course, is D&O insurance. And I think it's important to define, though, what that normally is. So director obviously means that if you're on officially a board of director, on the board of directors of an organization, then directors have a certain coverage limit as to accident emissions, et cetera, et cetera. But notwithstanding that, there's the rest of us, right? So I think that the question then turns to, is the CISO, the Chief Information Security Officer, for example, actually a named officer of the corporation, company, whatever it is? Are they listed like literally on the corporate record with the state, with that particular state's corporations bureau as to where they are originally incorporated? If yes, then I would then pick up the phone, talk or send an email to your legal counsel and just simply, as well as I would say someone in your finance department, to see, okay, can we set up a conversation to say, to what extent am I covered? What does the policy actually say? And I say that and I emphasize that because there are many CISOs that I've encountered that are vaguely aware that they may be covered, but they haven't actually found out whether or not that's true from their employer. And secondly, there's also the thing of, well, maybe they've been told that there's a policy, but they've never read the darn thing. And as we know from insurance law, unless something is specifically included, such as by way of an endorsement or otherwise, it's excluded. That's generally at least the way that works, at least in the US. So that's something to consider. There are certain coverages where the policy may also extend to protect a director's or officer's personal assets, personal liability. That's a certain type of coverage, and that's something that is certainly, I think, a discussion point between one's insurance representative and the company which hires you. The other thing that I would also suggest as well is there, for example, indemnification? If you have an employment contract, for example, or if it could be separately negotiated, can you, again, have a face-to-face or at least some kind of discussion with counsel at your company and say, hey, to the extent that I might not be covered, or to the extent that I might not be covered at all by insurance, could I potentially be indemnified? And then that's certainly time that I would recommend that a person also thinks really hard and considers, do I retain my own private counsel to review this contractual provision? And I think those things are very important because, of course, it goes to one's personal liability. And I think we should know at least that just because an attorney works for a company and they might be a nice person, in terms of their professional ethics and their professional responsibility, that only extends to the best interests of the company. And should your interests be contrary to that, unfortunately, you might be left holding the short end of the stick, so to speak. So there certainly is that. There are also things like errors and emissions policies. You can go through that with counsel and or your finance department to see if there's any kind of coverage at all. But I would certainly get something in writing that says, yes, you are covered under this policy affirmatively. And or if it's not clear, they say you aren't covered, you could also ask, and this is sometimes possible, you could also ask the people at your company and the insurance representative, is it possible for me to be added as an additional insured? And if that's the case, then yes, as an additional insured, you will be added subject to these coverage limits in X, Y, and Z and 1, 2, 3. So that's yet another approach.
This is very helpful, and I think all this, I would imagine, is advisable to do now before you actually need to find, before you actually there was a breach or an incident or something that where you as a CISO may be potentially exposed. It's obviously better to find out exactly where you stand in terms of D&O, in terms of indemnification, because you obviously ideally would need to consider even finding and retaining a personal counsel before you need one, rather than scrambling and figuring out where you stand individually in case something happens.
Yes, and I think that's absolutely correct. I mean, there are some other things though that I believe defensively the CISO can do to protect themselves. So I've followed recently some of the cases that have happened. And as we know now under the new SEC mandatory cybersecurity disclosure rules, we have to file periodic statements about incidents that happen when the incident is determined to be material. And we also need to disclose things in our annual reports about how our program is managed and how there's oversight. So with that in mind, I would certainly see what I could do as if I were working for a private company or even a public company as a public company as CISO. Can I see that statement before it's filed? Because I think it's very important, because you want to make sure that you are referred to in a light, if your actions are described at all, in a light where you actually agree with what's been characterized. Because sometimes, let's just say, those words can live forever, and sometimes they could be a good reflection, or at least a neutral reflection, or depending upon what it says, it could potentially be a negative reflection. So that's something to keep in mind, to see if you would have any kind of right of review or ability to see before it's actually finally filed.
Makes a lot of sense, and also it's interesting. If you recall, in the past, companies, when breached or if there's an incident, they had various degrees of how they communicate that. Meaning, oftentimes the company would try to remediate, address the issue, find the leak, restore everything from through disaster recovery, so that on the surface it's kind of smooth sailing, because there are reputational risks, there's potential loss of business if the breach is disclosed, there's potential disruption of business. So they understandably, a lot of times companies previously would like to fix the breach as much as they can before disclosing it to the public, before disclosing it to employees, before disclosing it to the customers, before disclosing it to authorities. And now with the CC requirement, especially for public companies, very stringent, I think it's like 3 or 4 days within which you must disclose a material breach, which is contrary to the practice that a lot of companies followed before. And the CISO is kind of caught in the middle. On the one hand, he or she may receive certain guidance or direction from senior management, from the board, in terms of how they prefer to handle the information flow. And on the other hand, you have federal agencies breathing down your neck, which puts them in a very kind of delicate position. Will be your advice, again, without kind of going specifics, and probably maybe it's too broad, how to navigate this seemingly at times contradictory incentives in terms of disclosure? Because it seems like, and again, from me, an outsider, kind of looking in and reading some of those cases where some of the CISOs got in trouble, specifically around how sharing the information, how communication happened after an incident, after a breach.
Yeah, I mean, I would say as to the first part, the CISO needs to understand that what SEC says in terms of materiality doesn't really mean that it's material from a technical perspective from the CISO's point of view. It actually means, as SEC had said in its final published rule in the Federal Register, that it actually is a determination of materiality as deemed by your entity, if it would, for example, influence an investor in a material way as to whether or not to, let's say, invest in a company. So it's material from that perspective. And that's why sometimes the CISO's determination may align with, let's say, the board's decision and or legal counsel's decision in terms of materiality. Sometimes it may not. So it just simply depends. It's a business decision. So I think to that extent, the CISO should not, I think, feel as though there's pressure that depends upon just that individual alone. It's certainly a group decision, a corporate decision. So there's that. But the other thing I think that can be learned, at least from the cases that have been published to date, is we all, regardless of the context, we need to be careful about what we may say to others, whether it's in any form whatsoever, whether it's to a coworker or colleague as an offhanded comment, or whether it's something that a person may say in a Teams or Slack or other chat. We need to always be intentional in terms of what we are saying and be consistent with our thoughts regarding, let's say, what is potentially a major incident. It's really when one gets into the realm of he said, she said, that we have a conflict and when that might get a wee bit messy. So I would say from a CISO's perspective, there's nothing that I'm aware of that would prevent the CISO from keeping even something as simple as a personal journal as to a certain incident. And I talked to X such and such a date, or I had a meeting with these individuals and disclosed X. And as long as you're taking notes contemporaneously or soon after that happens, even just for your own personal record, that way it's far less messy should, God forbid, something occur in the future, right? And that's what I was, I think, trying to allude to in terms of that's a wonderful way to be defensive, albeit in something that I don't think anyone could object to.
It makes perfect sense. I think it's great advice, Lee. This is super helpful, and I really appreciate you sharing your thoughts on this. I know we're coming up on time. Where can people find you? What's the best way to connect?
I'm a big fan of LinkedIn, so I'm just simply at linkedin.com/in/LEEKIM. Yes, there are a lot of Lee Kims in the world, but I'm the one person in cyber, at least as far as I know today. So
Well, you also have JD after your name, so it probably makes it even more specific.
that's true too. That's true too. So LinkedIn is a really good way to get in touch with me. I'm also on the faculty with IANS as well, where I mainly function as a legal-esque kind of consultant to people whom we talk to there, healthcare or otherwise. But I would say, yeah, I am always open to connect with people, to answer questions, or even to say, how can I help you? Because I just think unless we're helping each other and helping to protect people's lives and infrastructure and, just do good in the world, then that kind of speaks for itself, right?
Absolutely. Well, you only succeed together. In cybersecurity, I learned over the years it's a team sport, and it's changing so fast that the only way to figure things is with the help of others. And I appreciate your sharing your ideas and your thoughts with us today.
Absolutely. Thank you.